Institute was a policy writing challenge with other Institute of Politics throughout the country. Our team ended up winning after being judged by former Congressman John Tester in a fully funded trip to Chicago. The Student Advisory Board is a bipartisan group whose members can access many great opportunities through their involvement with the Institute, including volunteering at programs, networking with our special guests, and professional development opportunities. If you are a student and would like to join the Student Advisory Board, please email us at dolesab@ku.edu or speak with a student worker after the program. A video of today's program will be available on our YouTube channel. You can also access videos of past programs by visiting our YouTube channel. A loop hearing system is available to use if you have a T-coil hearing aid. We also have a limited number of listening devices. If you have questions about the loop system, or if at any time during the program you have difficulty hearing, please alert one of our staff members. After the program, we will have some time for the audience to ask questions. If you have a question, please raise your hand and a student worker with a microphone will come to you. Please stand if you are able and ask just one brief question. If you are a part of our virtual audience, you may submit your question at dolequestions@ku.edu. The Dole Institute mission is to foster civil and respectful discussion around important and often difficult topics. Please raise your questions with this in mind. Before we begin, I'd like to remind you to please turn off your cell phones. Now please join me in welcoming Dole Fellow Matt Beat.
Thanks, Jacob. Yeah, so I am Matt Beat, known as Mr. Beat on the internet, and I'd like to thank you all for being here today, for being curious about the power of the presidency. That's the theme of all these programs. This is the third one. If you missed the first two, I do see some familiar faces, though, so thank you for coming back. But if you missed the first two, they are on the YouTube channel at Dole Institute of Politics. Just search it up on YouTube. But yeah, today we're looking at the Supreme Court. And I may be known more online as the guy who makes a lot of videos about American presidents. That's why I designed this program here. But I'm also just as passionate about the Supreme Court. I have a series about the Supreme Court called Supreme Court Briefs, and I wrote a book about the Supreme Court. I chose 100 cases that I thought were the most important that every single American should know about. And I just think we should, yeah, the Supreme Court can be boring, but my goal is to just get people interested into what they're doing. So yeah, the President of the United States has certain powers. Let's just a little bit of a review here. What the President actually does. They're in charge of the executive branch of government. So they're the commander-in-chief of the federal troops. So that means they have the final say on what the military does. They enforce all federal laws. We discussed last time that typically they do this through executive orders. They sign bills into laws, or they veto them. But I think another part of the president that we forget about is that they're the symbol that represents not only a political party, but they're a symbol to the rest of the world of the entire nation. But the president can't just do whatever the heck they want. So we're going to focus on, yeah, I heard an amen on that. So today we're going to focus on the relationship the president has with the judicial branch in particular. It's a bit different. The main thing the president can do is influence the courts through their nomination of justices, federal judges and Supreme Court justices. Most Americans, they're aware of that. It's usually a dramatic process these days. So we're going to mostly look at the Supreme Court, but keep in mind that it's also the entire federal system of courts. Now, the Senate has the final say of their approval, but most Supreme Court justice nominations do get through. By the way, there have been 37 unsuccessful nominations to the Supreme Court of the United States, which, when I looked it up, it was higher than I thought it was. So there's a fun fact for you. Still, since 1790, there have been just 116 justices in the Supreme Court, just 116. It's a pretty exclusive club. Not as exclusive as the president, but it's currently made up of 9 people. It wasn't always. There's been less. There's been more. I should say fewer, sorry. But yeah, the Supreme Court, they're at the top of the judicial branch of the American federal government. And what do? They interpret the law. Interpret? Interpret? Well, humans can interpret things however they want to, can't they? I mean, this is why I used to, when I taught my students about American government, this is why I call it the what-if branch. Like, there's so many different scenarios, so many different possibilities. So this alone is a tremendous, tremendous power. And just, one interpretation by the Supreme Court can be carved in stone almost as a precedent that can be used for decades, if not centuries. And then just like that, the Supreme Court could just be like, I'm going to interpret it differently now. We're going to reverse precedent. Of the 7,000 to 10,000 requests for cases the Supreme Court gets every year, it only takes about 80 to 85 of those. So there's a lot of things that they would like to tackle, but they just don't have the time to do that. One notable power they have is the power to overthrow decisions of all courts underneath it. The Supreme Court's power has grown tremendously since the early 1800s. We're going to talk a lot about that today. And thus so has the power of the president in nominating them. That's why we even make it a big deal, because the Supreme Court is so powerful. Throughout American history, the court has also shaped what we collectively define as free speech, voting rights, equality under the law, privacy, freedom of and from religion, the rights of the accused, the types of punishments the accused get, and the role of the president, among other things. Not only that, its impact has grown almost out of necessity in recent decades because we are currently living in an era when Congress compromises and coalitions are becoming more and more rare. Therefore, the court has often stepped in to effectively legislate from the bench. There's no doubt that some of the most influential changes to American public policy have only occurred due to the Supreme Court. Take Brown versus the Board of Education, a case which originated just 25 miles from where you are right now, ultimately ended racial segregation in this country. Or a more recent example, Dobbs v. Jackson, a decision that caused several state legislatures to immediately pass laws to either severely limit or even outright ban abortions around the country. So in this series, we have been looking at I'm repeating myself here, but it's worth remembering. We have been looking at the power of the President of the United States. And in this program, we are specifically going to look at how the Supreme Court has tried to limit the power of the President, typically through the power of judicial review, or the process in which the judicial branch determines if something is constitutional or not, or if an action is constitutional or not. We'll also look at how the court has granted additional powers to the president. Before we begin, it's time for me to introduce my special guest who's been waiting patiently. Sorry to keep you waiting. I felt like that introduction was too long. Note to self, next time I do this in 10 years, don't make it this long. Okay, but my special guest is Clay Britton. He is a lawyer who has worked in federal and state governments as well as in the private sector. For the last 6 years, he's also been a lecturer at the University of Kansas, where he teaches a constitutional law class that also focuses on government powers. So that works out. He began his legal career in 2009 as a prosecutor in the Kansas Attorney General's office, then worked at a large Kansas City firm for 6 years before becoming an assistant United States attorney in Kansas. Britton then served as chief counsel to Governor Laura Kelly for the first 3 years of her administration. Today, he is senior vice president and general counsel at Blue Cross and Blue Shield of Kansas. He received his law degree from the University of Kansas School of Law, heck yeah, in 2008. Let's all give a warm welcome to Clay Britton.
Hello.
All right, this is where I...
Let's do this.
All right. It's going to get intense, Clay.
Okay.
You ready for this? Okay.
I think so.
So we're going to go back in history to the early 1800s. The Supreme Court justices back then didn't really have that much power. In fact, the Supreme Court was kind of an afterthought to the founders. They're like, All right, I guess we'll come up with Article 3, but let's just make it short because, you know, judges. But then comes along this guy that I used to nickname Little John, very charismatic fellow. His real name is John Marshall. How did John Marshall make the Supreme Court relevant?
Well, that's a great question, and I'm going to answer it in a way that I bet I see a couple of my former students in the back. They could probably answer it too, because it goes back to Marbury versus Madison, probably the case of cases, the seminal case in the Supreme Court's history, and it established the concept of judicial review, which is not something that was necessarily going to happen in our constitutional system. Judicial review is just the idea that the courts get to say what the law is, and even further, that the rest of the federal government might be bound by what the courts say the law is. If you go back and look at, you know, the debates over ratification of the Constitution and the Constitutional Convention itself, it was not clear to all of the founders, it certainly wasn't clear to some of the Jeffersonians early on, that the courts could tell the other branches of government what the law meant. They didn't have that sole authoritative role of interpreting the law and saying what the law is. So, you know, John Marshall comes to a Supreme Court in, let's see, 1801, right as the Adams administration was shutting everything down and Jefferson was sweeping in with his revolution of 1800. And you know, the Supreme Court doesn't have its own chambers. At some point, they get a basement room in the Capitol because that's how much of an afterthought they really were. You know, Washington and Adams, I think, had trouble, you know, keeping the Supreme Court actually staffed. A lot of the folks who Washington came to with, you know, nominations said, like, no thanks, I'd rather be a governor, I'd rather be a senator, I'd rather just practice law, I don't want to be in this basement Supreme Court situation. And so Marshall comes along, and Marshall is an ardent Federalist. You know, he had been Adams's Secretary of State, and so as he's going out the door as Secretary of State, Adams is like, hey, I've got another gig for you. This one comes with lifetime tenure. Why don't you go be Chief Justice of the Supreme Court? And so he does, and when he goes to the Supreme Court, he brings along with him not just all of sort of the Federalist views around judicial review and the authority of the court to say what the law is. He brings a sort of a politician's and a former soldier's ability to, pun I guess intended, to marshal a coherent judicial philosophy out of his colleagues on the Supreme Court, which is not something that you had in the first 10 years of its existence. So here comes Marbury versus Madison, a case that we can talk about more of the details if we want, because it's an amazing piece of judicial drama. But Marbury versus Madison is the first time that the court, and really Chief Justice Marshall, says the court gets to say what the law is. And once we say what the law is, President Jefferson, the Speaker of the House, all the other judges, even ultimately states and their officials in their courts have to follow what the Supreme Court has said. And that was not by any stretch written into the constitutional text or structure. It was sort of a leap that he took, and a leap that without that, we certainly would not be in a place where we felt that the Supreme Court was in any way able to strongly limit the president's power or Congress's power or the power of the states. In a lot of constitutional systems, you have a Supreme Court, but it does not have the kind of power that ours does, and that's because ours has judicial review that was set out for the first time in Marbury versus Madison.
Yeah, that idea that, like, this is what the law actually means. And I think that's what's even more profound is this is what you, as somebody in government, can or cannot do. Mm-hmm. Like, whoa, okay, here we go. Mm-hmm. Yeah, I mean, I've actually made a couple videos about Marbury v. Madison, but maybe just like a quick 1 minute review. What was the case about?
Well, it was about this guy who wanted to be a justice of the peace. I think his name was John too, but his name was John Marbury. And so he is one of a flurry of appointments that John Adams makes going out the door. So in addition to nominating John Marshall as Chief Justice of the United States, he also nominates Marbury to be a sort of local justice of the peace, I think in D.C. And Marbury's commission sits on Marshall's desk, so Marshall still has this role to play as Secretary of State, and he just has too much paperwork, and the clock runs out, and he doesn't get around to doing the paperwork part of nominating Marbury to his Justice of the Peace role. Jefferson comes in, his new Secretary of State, James Madison, sees this pile of paperwork, and they say, well, we're not going to complete the paperwork on these Adams appointments. We don't want all of these Federalist officials out there with these plum jobs, so sorry, Marbury, you don't get to be a Justice of the Peace. He brings a lawsuit saying, no, I was appointed, I was nominated, I should have my job, basically. And he starts, this is the problem that he and his lawyers eventually run into, is that he starts in the U.S. Supreme Court. Instead of starting in a lower court and working his way up. And there was a law in the books that said the Supreme Court could hear cases under its original jurisdiction involving these kinds of disputes, and it was the Judiciary Act of 1789, and what Marshall just was a genius about was he actually found a way to say that the Judiciary Act of 1789 was unconstitutional so that Thomas Jefferson and James Madison actually win the case, and they do not have to appoint Marbury to his position. And so Marbury loses the case, and he's really an afterthought in all of this. It's really a battle between federalism and Jeffersonian, republicanism ideas around what the court can do. And the great thing is that Thomas Jefferson actually won the case. He had nothing to complain about because what Marbury versus Madison ultimately said was the Supreme Court didn't have power to hear the case. But in the Supreme Court saying it doesn't have power to hear the case, it was also saying, and we have the power to decide what the law is. And that was the bigger principle that was at issue there. So that and one other case that we may talk about are probably my favorite Supreme Court cases because of just the genius with which Marshall kind of navigated through this. How do I tell Thomas Jefferson that he has to listen to me in a way where he has no choice but to listen to me? And it's let him win the little battle in front of the Supreme Court, but lose the big battle about judicial review.
Yeah, they couldn't have known the impact back then, and now it's like the most important Supreme Court decision, arguably, in American history.
I think so.
Yeah, little did they know, but maybe Marshall didn't
Marshall
know.
knew. Marshall knew what he was doing, I think.
Yeah, I'm telling you, he was a charismatic dude.
Yeah.
But yeah, so other cases further expanded the Supreme Court. I mean, mostly we're talking about the Commerce Clause, but we're jumping ahead here to the first time really a president's actions were challenged. So we're talking about Andrew Jackson. Probably, I bet you a lot of people would have guessed that.
Yeah.
So Andrew Jackson, he's trying to expand the power of the presidency. We discussed this in the previous two programs. How did John Marshall try to limit the power of Andrew Jackson?
Yeah, it's interesting. I think that Andrew Jackson is sort of that poster child for I don't care what the Supreme Court says. There's the potentially apocryphal line about, John Marshall has made his opinion, now let him enforce it, in regard to that Worcester versus Georgia case, which is interesting because that's the one we often point to as the case where, Andrew Jackson or a president defied the Supreme Court. I think it's a little bit more complicated than that to a degree. I mean, the funny thing about Andrew Jackson is, although he was no fan of John Marshall, and they certainly were on opposite ends of kind of a political spectrum, John Marshall was, upheld the constitutionality of the National Bank, 10 years before Jackson came along and vetoed its renewed charter. And there were these cases, Worcester versus Georgia, one of them, talking about dealing with Indian relations and in particular removal policies. Andrew Jackson was a big fan of those things, and John Marshall was putting these obstacles up in the way of federal efforts to a degree, but really state efforts to regulate and deal with Indian tribes. And so that Worcester versus Georgia case is interesting because it's about Georgia and it's about the Cherokee Nation, and it ultimately is an opinion in which Chief Justice Marshall and the court say that Georgia does not have the authority to regulate who gets to live on tribal lands, in this case Cherokee tribal lands in Georgia, and says this is actually a federal issue. The federal government gets to do all of the regulatory work around these tribal lands, and Georgia, you don't get to make laws about who gets to be on that land or not. They had arrested some missionaries who wouldn't, I think, give an oath to the state of Georgia in order to live with the Cherokee. And so at the end of the day, the court tells Georgia, you can't enforce your laws with regard to these tribal lands. And Andrew Jackson has the opportunity at that point, because Georgia says, well, we don't really care. We're still going to hold these missionaries in prison. We're going to prosecute them. Although they were trying to pardon them at the same time, I think. But they say, we don't have to follow, this Supreme Court opinion. That's an opportunity for the President of the United States to come in and say, yes, you do. The Supreme Court said that the federal government has the exclusive power to regulate the Indian tribes, and you're regulating it, and so I'm sending in, the National Guard to go enforce these laws. Andrew Jackson absolutely did not do that. He was not interested at all. So it's kind of a complicated case because it's not like he directly defied an order of the Supreme Court or something like that. But he did not do what we would expect in sort of the 20th century, at least, and what other presidents did do to enforce Supreme Court orders, even if they disagreed with sort of the policy ends of those orders. So it's interesting because I don't know that the court effectively actually limited Andrew Jackson's power in any real way, but certainly frustrated him quite a bit in terms of those two big sort of policy issues.
It's believable that he would have said something like that.
It sounds like something he would say, which I think is
Yeah.
why it has lived on, even if it may not be technically accurate. So
Exactly.
Yeah.
All right, so then, it was a tragedy afterward. Ultimately, the Cherokee were removed from their homeland and sent it on the Trail of Tears to Indian Territory. And then we have another truly tragic event, the bloodiest war in American history, the Civil War. And, last program we talked about how in wartime, obviously, the president is expected to do more. I mean, it's just, there are emergency powers for a reason. And so Abraham Lincoln, as president, did exercise emergency powers. He did things that tested the Constitution, but in the early years of the war, it was mostly unchallenged. But there is one case. Do you want to talk about how the earlier cases first, then get
Sure.
into the case? Okay.
Yeah.
So you mentioned there's a couple cases, like the prize cases and ex parte Merriam.
Ex parte Merriman, I think, was kind of the first one that involved the suspension of habeas corpus at the sort of front end of the Civil War in 1861-62. And that case is kind of interesting, too, because it's not really a Supreme Court case. Chief Justice Taney, who along with Chief Justice Marshall were like these two giants of the Supreme Court, Chief Justice Taney was actually sitting as what's called a circuit justice, like a trial court at the time, when he heard this challenge against the arrest and detention of Merriman in Maryland. And the details are probably not that important for our discussion, but essentially this Merriman was a Confederate sympathizer and may have been involved with, not being good, not towing the line in terms of protecting and safeguarding the Union at the time. And so he gets arrested, and Chief Justice Taney hears the challenge, the habeas corpus challenge, to his detention. And the idea of habeas corpus is just that in our Constitution it says, you can't be held without the opportunity to challenge your detention. And so habeas corpus, this Latin phrase that means bear the body or bring the body, is this system or this process we'd have to challenge your detention. And the suspension clause in the Constitution says that in times of rebellion or war or insurrection, the writ of habeas corpus, or the privilege of the writ of habeas corpus, can be suspended when, the situation requires it. So Lincoln suspends it at the beginning of the Civil War. And what's kind of curious is that the suspension clause around the writ of habeas corpus is not in Article 3, which is about the judiciary. It's not in Article 2, which is about Congress, about the president. It's in Article 1 about Congress. So the thought is, and Chief Justice Taney's, I think, reasoning was that this is a power that Congress has, not that the president has. The president can't suspend the writ of habeas corpus whenever he wants to. And so he issues an order saying that Merriman needs to be released. But his order is really soft. It's kind of like, hey, somebody tell President Lincoln that Merriman needs to be released, please, for me. Thank you. This is not an order from the Supreme Court or an opinion. It's not in the United States reports, like all the other Supreme Court opinions are necessarily. And so it doesn't really, the Lincoln administration, it's unclear whether Lincoln really knew about any of this in the first place, but certainly the military that was holding him didn't immediately release Merriman. They did transfer him to the civil authorities after a while, and ultimately he was never even prosecuted. Mm-hmm. So that one was like the first hiccup along the path of Lincoln and habeas corpus. The second case, the prize cases, that's one where actually the Supreme Court definitely deferred to presidential authority in a pretty big way. The issue there was basically these ship owners had tried to run a blockade of southern ports, and the Navy took the ships, took the material on the ships as contraband and held it, and the ship owners were like, hey, we want our stuff back. There are thousands of dollars of goods on those ships, and we want our money back, basically. And so the issue in the case was there a state of war that existed that would justify the government putting a blockade on southern ports? Because if a state of war exists, then the law of war says you can institute a blockade, and when people try and run the blockade, you can take the stuff and you can keep it. And so in that case, the Supreme Court, now this is the Supreme Court, not just one Chief Justice, but the Supreme Court said, essentially, we don't know when a state of war exists. We have to look to the executive branch and to the president to know whether a state of war exists. It's almost like a political question that they don't have the authority to answer, because at the end of the day, they're judges. They're not the commander-in-chief. They're not the Navy or the Army dealing with armed conflict. And so that, I think, established for the first time that there are these commander-in-chief issues that the court is going to steer clear of and is going to defer heavily to the president on. And you didn't really have any other trouble along those lines with the Lincoln administration during the Civil War, but he did run into trouble later.
Yeah, so a lot of people in the North, we assumed that like everybody in the Union was like on board with the war, but no, it was controversial in the North. There were protests, and if there were some people who were perceived as Confederate sympathizers, and some of them to a point where, yeah, they got in trouble with the law. They were taken to court, but there were people that actually were helping the Confederates. And so one such case was Ex parte Milligan, which is a landmark decision. And yeah, this is a big deal. Why? Ex parte Milligan, 1866.
This is maybe my second favorite case for a variety of reasons, but essentially the holding in that case is the president doesn't get to suspend the writ of habeas corpus in general, but also specifically not in areas where everything seems to be fine. Because what Lincoln and the military tried to do was, in this case in Indiana, said we're going to prosecute in military tribunals anybody who we think has been supportive of, the Confederate cause.
Even civilians.
Yeah, it's including civilians. And so this guy, Lambton Milligan, was a troublemaker in Indiana. He gets arrested and put through this military commission where he gets sentenced to death for treason. And so the issue was, hey, this is Indiana. This isn't Alabama. This isn't Georgia or South Carolina. federal authority is still alive and well in Indiana in 1863, 1864. If you want to prosecute somebody for something, you can just arrest them with the civil authorities and send them to regular courts, and they can have the protections of the Sixth Amendment and all that stuff in their trial. And you don't have to do this through a military commission. And so what the court said is that when the civil authority is still intact, when you have the opportunity to use civil courts, you have to use those. You cannot, in a sense, declare sort of martial law, suspend all these constitutional protections. So that is a line that I think no president has ever crossed since, and of course we haven't had those kinds of circumstances since, in terms of trying to, outside of an actual war zone, suspend constitutional protections that would otherwise apply to American citizens. What I think is really what I love about the case is that the justice who authored the opinion is a guy named David Davis, and he's like Lincoln's best friend. He was a judge in Illinois, and they would ride circuit together. Lincoln argued like 100 cases in front of him. They were best buds. David Davis was the one who basically organized and executed the strategy for Lincoln to be nominated on the Republican ticket in 1860. I believe he was Lincoln's first appointment to the Supreme Court in 1862. After Lincoln died, David Davis did two things. One was he was the executor of Lincoln's estate. Lincoln didn't have a will, and he stepped in and dealt with administering Lincoln's estate. And then at the same time issued an opinion in 1866 saying that his best buddy was completely off his rocker and unconstitutional when he tried to impose martial law in Indiana, during the Civil War. And so I just love the idea that David Davis, even though he has this personal relationship with Lincoln that is super strong, is also not afraid to call out what he saw as a pretty significant overstep by the executive in the context of the Civil War.
After he was dead, though.
After he did wait. Yep, that is true. Yeah,
I couldn't help myself.
Maybe they're fighting about it now, but
maybe they're up there
Lincoln
fighting
couldn't
it, yeah.
exactly respond in 1866.
Yeah. Okay, so we're going to fly through several decades now. So after the Civil War, we had justices in there who generally were more hands-off with instructing the federal government to be more hands-off and to give state governments more power, more cases about substantive due process. This is kind of known as the laissez-faire era too, like especially in the early 1900s, despite the progressive laws that Congress is passing, the courts kind of stay conservative, saying, no, federal government can't do that, man. And so we do have Congress giving all this additional power to the federal government, but the Supreme Court is, limiting, or at least just not even considering challenging these laws, or no one is, because maybe they don't think the court's going to side with them. So we're just jumping all the way ahead to the New Deal, to the early years of the presidency of Franklin Roosevelt. And when Franklin Roosevelt had these New Deal programs, they were extremely popular. He had, super majorities in both houses of Congress. So the public was on his side, Congress was on his side, things are happening, boom, 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 but then the obstacle remains the Supreme Court. So first, what were these obstacles? And then second, how did Roosevelt fight back against these obstacles?
Yeah, this one's interesting too, because the obstacles at issue weren't really about presidential power, even though they implicated this fight between the president and the Supreme Court. The obstacle was around the Commerce Clause, and what does it really mean? What can the federal government as a whole do to regulate commerce that might be, in some senses, feel very local? But the Commerce Clause, we call it the Interstate Commerce Clause, because on paper at least, it kind of sounds like it's just about commerce that crosses state lines. So if you're an article, a good that is put on a barge that goes down the Mississippi River or something, hey, that's interstate commerce. That's easy. That's something that the founders certainly would have thought of as interstate commerce when the Constitution was adopted. But as the economy becomes much more interconnected, not just sort of interstate, but international, you have many more sort of regulatory needs that the federal government would like to meet. And the Supreme Court kept saying in these New Deal pieces of New Deal legislation that would come along, oh, this is beyond the federal government's authority to regulate commerce. This has to be left up to the states because that does not qualify as interstate commerce. So if what you want to do is regulate, the working conditions in a factory or something like that, you're not allowed to do that. That's left up to the states. And so when Roosevelt and his New Deal come along, and they want to pass all these new bills around, labor relations and working conditions and financial policy and all of that, the court keeps saying, no, the federal government doesn't have the authority to do those things. So it's not about the president's authority per se, it's really about legislative authority. But Roosevelt's not happy about this. He's like, I campaigned on a New Deal, especially in 1936, and I want to follow through, and I've got basically a bunch of old guys on the Supreme Court who don't get it. They don't understand. And so what he starts to argue is that they're so out of step that we really need to change the composition of the court. And he didn't, constitutionally, these justices serve during good behavior, which means they have lifetime appointments unless they get impeached for really bad behavior. And so his idea is to essentially pack the court by saying for every Supreme Court justice over the age of 70, the president gets to nominate another justice. And so over time, he would be able to balance the court out with, some young hip justices, like in their 50s or 60s or something, who would be able to get it, to understand what we're trying to do with the New Deal, and that the Constitution needs to have some elasticity to allow it to be adopted and adapted to different times.
He called on Congress to pass the law. It's not like he was saying this was an executive order or anything.
Right. He was not going rogue necessarily.
Yeah.
He was going to Congress and he was going to the people. His fireside chats would talk about this, and he was doing what presidents do, marshaling political support to make a change that would impact the way the Supreme Court was ruling on these cases. And it's a little controversial whether his efforts were fruitful or not, because certainly he got his way, because the Supreme Court in 1937 started interpreting the Commerce Clause differently and allowing these New Deal laws to go through as regulating interstate commerce. But there was, one justice, Owen Roberts, who was a Hoover appointee, that started voting with essentially the liberal side of the court to sustain these laws, and then everything kind of was fine in terms of FDR and his New Deal legislation getting through. If you look at the beginning of his administration, when he's dealing with all of this frustration with the court, you look at who appointed all of those Supreme Court justices he was dealing with. Well, he didn't appoint any of them. They were all Taft and Coolidge and Harding and Hoover appointees. And then you fast forward to, I think, 1942, and by then, every single appointee, every single justice on the Supreme Court is an FDR appointee, with the exception of one, and that's the guy who switched to start voting with him, who was a Hoover appointee. So it's pretty interesting to see how the court truly becomes FDR's over time. That's what happens when you serve 3+ terms as president, I suppose.
Yeah, I always tell people that justices are not, they are malleable. They change their minds. Don't assume that the justices that lean to the right today are going to always be that way.
Yep.
There was a journalist that said the switch in time to save 9. I love that line. But yeah, so now the 1940s, so we're getting to the end of World War II. Now Truman's in there, and we have basically, it's all New Deal appointees essentially now. We're in that world. I'm bringing up Truman. I wasn't going to bring up Truman originally, but you wanted me to bring up the Steele case and Robert Jackson. I think that quote by Robert, I know you don't have the exact quote in front of you, but just.
Or do I do.
Oh, look at you. Look at this guy. I
mean,
love it.
You know, I
didn't get a picture of him.
I used to be a real lawyer, and I'd have to prepare for things and stuff. So, yeah, this is a really interesting case. I mean, and the interesting for our particular topic because the steel seizure cases or the Youngstown steel case is squarely about, it's the Supreme Court really grappling in a big picture way with what kind of power does the president have. And in the majority opinion, they kind of gloss over some things, but Justice Jackson, who is a veteran of the executive branch, he was FDR's Attorney General before he was appointed to the court, writes this concurrence where he gives this tripartite framework of presidential power. He says, here's how presidential power works. You know, you've got these three different levels. Here, he doesn't have too much power. Here, it's kind of a close question. And in these situations, the president has exclusive power, even if Congress doesn't like it. But when he's talking about this, he mentions, because of, I think, his own experience in the executive branch, he talks about what the power of the president truly is. And he goes back to somebody that you have been talking about in the first two programs on this, Woodrow Wilson. Woodrow Wilson had said something along the lines of, you know, the presidential office is as powerful as any president wants to make it, as anybody, I can't remember if I wrote that one down. I did. If the president rightly interprets the national thought and boldly insists upon it, he is irresistible. So that's Woodrow Wilson. And Jackson's talking about how Wilson, you know, sort of showed that the presidency was just this, you know, far and away sort of a different quality of power than what the Supreme Court or the Congress had. And so when he's talking in this case about whether they should uphold Truman's action to nationalize these steel mills during the Korean War, he says, I cannot be brought to believe that this country will suffer if the court refuses further to aggrandize the presidential office, already so potent and relatively immune from judicial review. So Jackson's saying the presidency does not need any help. We do not need to give President Truman or the next president any sort of extra boost in terms of their powers. They have all the power that they need, and our job is to be careful and deliberate about circumscribing that power. So I think that gets squarely at sort of what this program is really about, and emphasizes, at least for me, the idea that as powerful as the Supreme Court is, and as concentrated in, you know, a few lifetime appointees their judicial power is, it's really nothing compared to the president's power. The president has far and away more opportunity to do stuff than the Supreme Court does, and certainly these days than Congress does. I think Justice Jackson knew that.
And when the Supreme Court got more power, they had to give it to themselves. Same with Congress. They had to give it to themselves. The president just kind of gets more power naturally almost.
It's a good way to think about it. It's almost like if the power hasn't been specifically assigned elsewhere, it naturally gravitates to the executive branch. That's just sort of the way it is.
Yeah. All right, I guess I picked a good topic for this program. So we just have a few minutes here, so I'm going to just kind of go through a few decades more quickly as well. We've got Earl Warren, and I think Earl Warren is probably the second most influential Chief Justice of all time. But the thing about Earl Warren is, and he's nominated by Dwight Eisenhower, Kansas represent.
Mm-hmm.
But Eisenhower, you know, after probably the second most important Supreme Court case in American history, Brown versus Board of Education, Eisenhower's just like, yeah, man, I'm going to enforce that. No questions asked. It's not like Andrew Jackson.
Yep.
Eisenhower, he enforces it. He sends paratroopers, federal troops down to Arkansas to make sure that those African-American students are protected going to school, to make sure that there is integration. And so, yeah, like, I mean, for several decades, we kind of just have a Supreme Court that's going along with the president's power. But it wasn't really changing, I thought, until we start to, like, get to, I think, the 1970s are a turning point. Like, because Congress in the 1970s limits the president's power, But then ever since, the Supreme Court has actually given the president more power. Would you agree with that?
Yeah, I think so. I mean, there are fluctuations along that pathway, but mostly, yeah, it's been a Supreme Court that has expanded presidential power as opposed to limited it.
I mean, I have several cases we could look at, so I'm going to throw some out, and you can focus on which ones you want to, because we just have a little bit of time. Buckley versus Vallejo. Let's see here. Bush v. Gore, Citizens United v. FEC. I know probably we'll get a question in the audience about Trump v. United States, so maybe don't spend too much time on that, because that's a pretty significant one that happened last year.
Heard of that one, yeah.
Yeah. But you were actually, when we met up before this, you were mentioning the appointment power cases. Like I found one, are you familiar with Collins v. Yellen? Is that one of the ones you were thinking of?
That is one of them, yeah. So there have been a run of appointment power cases over the last several decades. I mean, really they go back to the 1920s and these are really, I think, kind of the foundation of what we would call unitary executive theory these days. That's not something that ever showed up in a Supreme Court opinion or has yet. But the idea around the appointments clause is that, when presidents want to appoint somebody to be a high-level official, they generally need to have the consent of the Senate. And that would be true for all principal officers. So if you think cabinet secretaries, generally speaking, or heads of big federal agencies, we all know they have to be appointed or nominated first, and then the Senate has to provide their advice and consent through confirming that nomination. But the hard part is, what about firing those people? When does the president get to fire those people, and are there any limitations on the president's ability to fire those people? So that's what these cases are about. I call them appointment power cases, but they're really about removal power. And recently, we have absolutely had a Supreme Court that has sort of doubled down on the idea that the president needs to have pretty complete control over all the people who are doing the president's work, out executing on the policies and programs that the president is responsible for executing. And if the president cannot fire those people because, say, Congress has said this person can't be fired unless they, commit treason or something like that, or engage in moral turpitude or something, they put some limitations on that removal power, then you've got a problem, because now you're no longer putting the president in charge of the executive branch. So that's how it gets back to sort of that unitary executive theory. If you believe in a unitary executive, which to some degree our Constitution does, then the president probably needs to have, this is the Supreme Court's reasoning lately, the president probably needs to have the unfettered discretion to fire the people who are responsible for carrying out those executive branch duties. So we had a case involving the Financial Protection Bureau in 2021, maybe it was, that sort of doubled down on this idea that if you've got an important role in the executive branch, it has to be controlled by the president, which means the president has to be able to fire that person, that director. There have been other cases through the years around that idea. And so I think that's a big one where we've seen the court make some pretty big pronouncements about what it thinks presidential power entails. It entails having really complete control over the executive branch and all of the people working in it. And so obviously we're seeing right now some tests of that approach. The Trump administration has been very vigorous about exercising control over, many parts of the executive branch that in administrations past would have been sort of hands-off or left alone. So I think we're going to see some challenges around the removal power specifically in that provision of the Constitution.
Before we take questions, I just want to remind, if you're watching at home, or maybe you're somewhere else, I assume you're at home, maybe you're on a boat somewhere, I don't know if you have good internet, but if you have a question for us, just email at dolequestions@ku.edu. For all of you in the audience here, after this last question here, you'll have an opportunity to ask either one of us a question. And so just a reminder, just to raise your hand, and one of our student workers will go over to you and give you the microphone, but make sure you wait for the microphone so it picks it up on the live stream. You want to be heard. So, yeah, I mean, my final question, you probably already could predict, is about Trump v. United States, and, you know, that idea of official duties, also the idea of immunity, presidential immunity. So if you could hit on those 2 points related to that case.
Yeah, we still don't know what that case really means, and we may never know what that case really means. It certainly means, we know some things that it means. It means that this Supreme Court is relatively amenable to the idea that the president is special in our constitutional system and needs sort of special protections that may not be afforded to other parts of our state or federal system. It certainly has some level of impact on the idea that presidents don't have to answer to legal challenges during their administration. The big thing, of course, now is that for what the Supreme Court calls core executive powers, the president would never have to answer, even after the president leaves office, in a criminal prosecution for violation of the law, if those allegations relate to what the court has called like the president's core executive powers. So think of things like pardons or appointments or commander-in-chief responsibilities. But really interestingly, also the court mentioned investigative and prosecutorial actions. So that's what's interesting.
That scares some people.
Yeah, and I think that's kind of scary. So it'll be interesting because we may very well, with this president or the next one, we may very well have some tests of what the real bounds of criminal immunity presidents enjoy after Trump versus the United States. But the thing that we will absolutely have that comes from that case, there are all these pronouncements about what kinds of powers the president has, and they're pretty lofty, big-time things. I mean, because the court goes into a discussion of what the president's core powers are, it sort of necessarily outlined this grand vision of all these things that are exclusive executive powers that Congress ostensibly maybe cannot limit. And so I used to work in a state executive branch. I guess I used to work in the federal executive branch too. But if I were a lawyer working for a president, I would be quoting language from that case all the time about all of the amazing powers that the president has. And I would be bringing that up, not just in cases around, you know, some criminal action against the president or something, but in cases about what kind of appointment or removal authority does a president have. How can Congress, is the Impoundment Act of 1974 constitutional? I mean, I think it throws into question whether that act is constitutional because maybe it unconstitutionally limits the president's ability to do a core executive function of deciding when to spend money. I don't know. So I think there are lots of questions about that one that we may just have to wait to have answers on down the road.
They're going to be very busy in the coming years, aren't they?
I think so.
The Supreme Court.
Yep.
Well, Clay, I didn't meet you until last week, and I can tell you just from our short exchanges that we've had, you're a great teacher. Your students are lucky to have you. Thanks again. Let's give them another round of applause. Thanks for being here.
Thank you.
Yeah,
you're fantastic.
Appreciate you coming.
Yep, appreciate it.
That was awesome. And yeah, so we'll take questions here for a little while, and yeah, like I said, if you just raise your hand and somebody will come to you with a microphone.
So you touched on the president's ability to fire heads of agencies, but what is allowed? Does Trump have the right to do these mass firings? Does Trump have the right to abolish the Department of Education? If that's either unconstitutional or illegal, then whose job is it to stop it? Is that Congress? Is that through the court system? So inquiring minds would like to know.
So I think, first of all, there's a distinction between, in the constitutional sense, between principal officers and inferior officers. And an easy way to think about the removal power, this is not totally, if we were briefing this in a court, we probably would say it a little bit differently. But for principal officers like cabinet secretaries, heads of agencies, the president probably can just fire them. Probably needs to have the ability to fire them for any reason. When you get to inferior officers, so think of a lot of lawyers or, sub-cabinet agency, assistant deputy types. For those folks, there are a lot of civil service protections on the books that I think are constitutionally permissible, and you would need to have some cause to fire those people. So I think when we look at the broad swaths of kind of rank and file firings that are happening, the Constitution would absolutely say that Congress can limit a president's ability to fire those folks. And we have laws on the books that do limit the president's ability to fire those folks. If those laws weren't there, if Congress were to repeal them, then the president could probably fire all those folks. I don't think there's a constitutional protection for them. But statutory protections for them are constitutional, or at least I think they are. They have been so far. So I think that it addresses kind of the first part of your question. The second around like the Department of Education, and does the Trump administration have the authority to basically shut it down? And if not, whose job is it to say no? I mean, presumably, there's a set of statutes that creates the Department of Education, and Congress funds the Department of Education every year. They pass these statutes to create it. They appropriate money to fund it. You would think that Congress would be one of the places where you'd hear people say, no, you can't just shut this down. Your job is to take care that the laws are faithfully executed, President, and the laws create this department and fund it. And so you would hope that there'd be some response from Congress in that scenario. You could also file a lawsuit, and I'm sure lawsuits will be filed, that would challenge the president's authority to do that absent an act of Congress that would abolish the Department of Education. So I think what you'd be looking for is for Congress to do something about it. I think that's probably unlikely with this Congress. They don't seem that much interested in standing up for, their co-equal status in the separation of powers scheme right now. And so I wouldn't look too much there. But the courts will be interested in that. And then the question becomes, what happens if and when a federal court says, the Department of Education needs to still be a thing. And in the meantime, you've taken practical action to fire a bunch of people there and get rid of buildings and things like that. I don't know what happens at that point. So lots of question marks right now.
One thing I will add that you didn't say, but how can I top that answer? But one thing I will add is that when we talk about these departments, the funding is already said and done for. Congress has already decided. So when you hear people say, they're shrinking the Department of Education to make it more efficient, what are you talking about? Like, the money's already Congress already allocated all this money, and they do it every year. Every year they have a budget, and so when I think we're also going to find out from Congress is when the next appropriations bill that includes stuff about the Department of Education. That's when I think we're going to get a clearer picture of what's actually going to be cut. Because I just think the president's going to, just throwing a bunch of spaghetti at the wall right now.
Yep. I think a lot of it's going to stick.
Yeah.
There's just so much of it.
Okay, we'll take another question.
So what exactly is stopping corruption when a president appoints a justice? Say the president holds them to a deal, I'll appoint you only if you rule the way I want all the time. And from your knowledge, how possibly common is that in the history of the courts?
It's interesting. So I don't know. I mean, that's a good question.
Impeachment?
I think, yeah, certainly. But I don't know that it would be illegal in any sense. I mean, it might be, you might consider it a high crime and misdemeanor to sort of condition a Supreme Court appointment on you're gonna rule this way on these issues, right? I wouldn't be surprised if those kinds of discussions have happened, but you certainly don't hear directly about them. I think it would be I have a little bit of experience with this on the state level because when I worked for Governor Kelly, I managed the judicial appointments process for state court judges, and would do interviews with candidates and talk to them about their fitness for the role and all that. We would never ask specific questions about how are you going to rule on this thing if it comes in front of you as a judge, because we didn't feel like that was appropriate. But I'm guessing that not every president or not every White House counsel or attorney general who's been involved in those appointments over the years has felt the same way. So I think that's like an ethical boundary that I wouldn't want to cross, but I would be surprised if it's never been crossed. And then if that happens, I mean, there are large elements of our constitutional system that are predicated on people trying to do a good job and do the right thing, and I think that's one of them. There really aren't any limitations on having those kinds of discussions, and some people would call it corruption, and other people and I might disagree with those people, but other people might call it doing their due diligence, making sure that somebody they appoint to that seat is going to rule the way that they want them to. It's a good question, though.
Article 3 isn't that long, not much in there.
Yeah.
Anybody can be a Supreme Court justice, including my 10-year-old daughter, although she'd do a good job.
Yeah. We should get her on there.
And whenever the Supreme Court has had a code of conduct, it was on, like, they came up with it, right? Mm-hmm. It's like, oh yeah, we should have rules for ourselves.
It's all self-imposed.
So it's like we have this trust, but the other weird thing is, we just assume it's always going to be somebody who has judicial experience, but it doesn't. I mean, actually, if you go back far enough, it was more common for there to be people that didn't even pass the bar exam, bar exam to become a Supreme Court justice. So, but yeah, I would say you probably are thinking about one justice in particular. We don't need to name them, but I think that's where that question is coming from.
Yeah.
He's going to pick, Braden there. He has the power.
Obviously, it's been tradition for centuries that they have lifetime appointment. Do you guys feel like now, in current day, that's helpful or hurtful to how things are proceeding?
So I think it's both. I mean, I think that lifetime appointments create the kinds of problems that we talked about during the New Deal era and FDR, and you can absolutely have justices whose judicial philosophy, which is a form of political philosophy, is just not right for the moment. I think that can definitely be true. But the great thing about lifetime tenure is we do, I think, need some part of our government that does not feel the need to be routinely responsive to the electorate. And so, as I've kind of thought about the pros and cons of life tenure for especially the Supreme Court, I think you want to find some middle ground. If we were going back to 1787 and we were going to draw this up, from scratch, something like an 18-year single term or something would probably be maybe the best of both worlds, because you're insulated from all that political pressure. You're not running for another office, hopefully. And on the other hand, you don't get to overstay your welcome. And I think we've seen that can be a problem, sort of in terms of eras on the court, but also sometimes with particular justices who are just, like, it would be nice if we had some space for some new blood to come through. And I think we run into that with some frequency. But that's a tough one. I do think you need that insulation from political pressure, absolutely. But there maybe are other ways to get it that would not entail a lifetime appointment.
I would just say technology is a major factor. When you have justices who are not as informed as they should be about technology, can you imagine them deciding something regarding artificial intelligence?
They're going to have to do it. Yeah, it's coming their way. So
I do. Yeah, a compromise would probably be good. I mean, heck, Franklin Roosevelt, maybe he had the compromise when he said that you had to.
Right.
If you didn't retire by a certain age, then you get another justice. So it wasn't as radical as some like my history teacher painted it as radical when I learned about it in high school. Can you believe he wanted to pack the court? But maybe it wasn't so crazy.
Well, it certainly happened over the, I mean, packing the court, maybe not, but the court has grown and contracted in size.
It was 15 justices during the Civil War.
Yep. So,
Lincoln got his justices in there, all right.
yep.
We do have an online question from Nico de los Santos. How do the recent SCOTUS decisions concerning executive power compare to historical precedents, and what does this suggest about SCOTUS's current interpretation of presidential authority?
Well, it sums it all up.
Yeah. You want to go?
Sure, and you can correct me after I answer.
Oh,
but
yeah. Okay, good.
No, I mean, I think overall, I don't think we've ever really had a president test court decisions that much, and so the one thing that I am for sure is, and I said this at the beginning in my whereas now people literally will vote for president based on who they think will nominate as a Supreme Court justice. So that just shows you that power has shifted. Is it because of, like, I don't know if it was, does that mean the Supreme Court has agreed to automatically give the president more power? Not necessarily. However, like we said earlier, I think we'll find that out here in the coming years.
Yeah. I think, if you look at the 19th century, the Supreme Court didn't talk about presidential power very much. It wasn't all that big a deal. I mean, we had those cases during the Civil War. They were really around sort of the president's military or emergency powers. It wasn't until the New Deal and sort of the rise of the administrative state that all of a sudden presidential power became very controversial and very important. I mean, because so much of what the federal government might have done in the 19th century didn't really rely on what's the president's idea around how to enforce this or how to enforce that. What's the president going to do with the Environmental Protection Agency with regard to climate change or clean air or anything like that. But after the administrative state and after a lot of the legislation that we saw through the Civil Rights era in the 60s and the Clean Water, Clean Air Acts in the early 70s, now so many big questions implicate presidential discretion or presidential authority. And so now we have to have all these fights over what the president and the executive branch generally can really do. So it's kind of interesting if you want to sort of hold up a mirror between the modern courts' presidential power cases and, you know, the 19th century courts' presidential power cases. Like, there's really nothing to mirror in a lot of ways. Those 19th century cases were often not about the president's power at all. So it's interesting. I think we're in it's not completely uncharted territory. I mean, if you go back to the 30s, like, we've been talking about this stuff in some form or another for almost 100 years. But it's not like we have a bunch of cases from the very beginning talking about presidential power that today we can go, wow, we've come a long way from that. It's hard.
Hi. Oh, is there such a thing as an independent agency?
Yeah, if so, what does that mean? So I guess I would answer that question practically, first and foremost, by saying, yeah, there is. I mean, I think in a sense, the Federal Reserve is an independent agency. I guess now you could argue differently, but the Consumer Financial Protection Bureau is an independent agency. The National Labor Relations Board is an independent agency. I mean, because they are not subject to, sometimes they are not subject to specific, like, appropriations requirements from Congress, and they are not headed by sort of one single presidential appointee or something, and so they're not answerable in that way. I think, though, that if you were to ask that question to, 6 justices on the Supreme Court right now, they probably would say, well, I don't know that there should be a thing called an independent agency in the executive branch. Because if what it is doing is exercising executive power, if it's helping the president take care that the laws be faithfully executed, then it shouldn't be independent. I think that's what at least 5, if not maybe 6, current Supreme Court justices might say. And this gets back to that idea of the unitary executive theory. The issue gets a little more complicated when you talk about entities or agencies that might have some executive power, but also might have some legislative power, or even judicial power. Some of these agencies hear, enforcement actions and decide them in a way that a court might. Others promulgate rules in a way that the Congress might. And then others, too, might investigate and prosecute violations in a way that the executive branch might. So in those areas where you have quasi-executive, quasi-legislative powers put into one agency, I think you're more likely to be able to convince some Supreme Court justices right now that it's okay to be independent, at least of the executive branch.
Would that be like the ones that you cited?
Some of them, yes. So like the National Labor Relations Board, I think would probably be one that has a mix of those kinds of powers. The Consumer Financial Protection Bureau is one that I think is, in the court's view, in the case that they dealt with a few years ago, is probably more just executive in terms of how the court views it. There's some legislative and judicial stuff kind of going on there, but when you have multi-member led agencies that are that have quasi somewhere in what you would describe them as doing, whether it's quasi-legislative or quasi-executive or judicial, then I think you're probably more likely to be able to be independent in the way that we would think of like the Federal Reserve or something. So
It's a weird coincidence. I was just looking up the case, Humphreys Executor v. United States. It was a New Deal case where they defined independent regulatory officers' jobs as quasi-legislative and quasi-judicial. I always called the Federal Reserve quasi.
Yep.
It's just weird. It's in between because
it is in between.
And
yep.
Our first program. You want the name of that case again? It's Humphreys Executor v. United States. If you want to look it up later. But yeah, our first program we talked about how checks and balances isn't just amongst the three branches. It's within too, and these independent agencies often are. Checking the power within
Yep.
the executive branch. I think it's important to remember.
And that is the point. Good, because I think that there's a line of thought in jurisprudence now that would say intra-branch checks and balances might be unconstitutional. If you have a piece of the executive branch acting as a check in a constitutional sense on another piece of the executive branch or on the president, that may not pass sort of constitutional muster at this point. I don't know. But I think you're asking great questions about.
And getting rid of the Chevron doctrine, right, was a big deal related to all that because it kind of opens up the floodgates. The Chevron doctrine case, I don't remember the name of the case, but it was overturned.
Chevron is the name of the case.
It's just Chevron, look up Chevron case 2024, and they essentially, like this is like the first step towards unitary executive theory, like saying, giving the president much more control over the executive branch.
Loper Bright, the one that overruled the Chevron
Oh, that's it.
case.
Yeah.
Yep.
How do you do that? All those cases in your head. How do you
That's
check all that?
law school beats at India. So.
Okay, we have time for one more.
Thank you.
Oh.
You got to hold on to it. I have a question about responding to the exercise of presidential power. If you're a lawyer, and not everybody is, you could file a lawsuit, but they take a long time. Fewer people are judges. Congress at the present time and Congress people at the present time seem disinclined to listen to you if you want to challenge the current president. There aren't that many editorial writers who have any sort of stroke with the current administration. And so if you want to complain about the actions of the sitting president, do you have any recommendations about courses that might be effective?
It's a great question, and one that I struggle with routinely, usually during my drive to or from Topeka for work. But I don't know, I think all of the above is probably the only real answer. And so if there's something that you individually feel like you can do, you should probably do it. And so maybe that is reaching out to your member of Congress Maybe it is that you have the ability to file a lawsuit to get in, sort of get in the game on this stuff. But the other thing I think is just to make sure it's slow and painful and frustrating in a way that even like a years-long lawsuit is not. And that is doing actually, I think, what you all are doing here today, which is being engaged with the issues and being educated about them. I think that one of the problems that we've developed for ourselves that has caused us to be in a situation where we have so many question marks that we, are seeing everywhere we look, is that a lot of us stopped paying attention to this stuff, and we just don't. One of the things I tell my students when I get the chance to teach once a year is, I hope that at the end of the class, you will be able to see things reported in the newspaper, and I say newspaper, and then I realize they probably don't know what I'm talking about, reported on the TikTok, and understand the constitutional dimensions and implications of what you're seeing. And right now, it would be a great time to test some former students and see, okay, if you went on, pick your favorite news outlet's website, and you just looked at the headlines around what's going on with the new administration and with some of the legal challenges that have been filed, do you have an understanding of what sort of issues are implicated there? Do you have an understanding that when you see Elon Musk doing his Doge thing, that there is a real appointments power question about whether that is constitutional in the first place? Is this a principal officer who's been appointed and confirmed by the Senate to hold high office? I don't think so. And there's litigation around that's proceeding right now. And so, I think it's an all of the above and pay as much attention and educate yourself as much as you can about it kind of answer. And that is completely unsatisfactory to me. But that's the best that I can kind of come up with. Encourage people to come to these things. Encourage people to do the things that seem like it's not going to get anywhere. I used to work for Congressman Dennis Moore, and I started off by interning in his office. This was, the olden days of 2003, I think. And Dennis Moore was one of the good guys for sure, but he, like everybody else, was responsive ultimately to public opinion and to letters and emails that he got and to things people told him at events that he went to. And some of that has certainly gone away. We don't have a lot of Dennis Moores out there anymore. But they still will be responsive to public pressure and public opinion. It's just hard to see it in any given instance when you reach out and you try and communicate something to a representative, especially sometimes if that representative represents you but is more concerned about things going on the other side of the state or in DC as opposed to listening. But they do have to listen ultimately if enough people speak up. That's a bad answer.
No,
I wish I had a better answer.
Well put. I will just add because I did this a couple years ago. I don't know if you're familiar with my channel, but I called every member of Congress in a live stream. I called every member of the Senate in a live stream. It was live. You can go back and watch it how it really was. That's legal, by the way.
Sure.
In Kansas, I looked it up right before. And then later I called every member of Congress, but the problem was all the staff members, because it's just an intern that answers the phone. But a lot of them, word got around that I was doing this, and then so I got a lot of emails, and a lot of them didn't want me to disclose, like, don't tell them that I said this, but so I just want to say that actually that whole experience actually gave me more faith in our government. I know we just assume that these members of Congress are out of touch and that they care more about special interests or the donors who are giving them all the money to get elected or reelected. But actually, every single staffer, they have spreadsheets, and every time you call a member of Congress or write them an email, they keep track of it, they tally, and they truly do care what people think, and they want their finger on the pulse. They don't want to be out of touch, and so I think one of the best things, I know this is cliche at this point, but still one of the best things you can do is to call your member of Congress, to show up to town halls. Roger Marshall's going to have a lot of town halls in the next few months. Make sure you show up to those. But if they don't have town halls, emails and calls are effective. So I recommend everybody in this room, if there's something that worries you, you do need to do that. We're taking too much time, though. So I'll wrap this up by saying thank you for coming. The next program will be in 2 weeks on March 26th, I believe. So 2 weeks from today on Wednesday, 4 p.m. And that program will be looking at how the president's power is limited by state governments. So, how does Topeka limit the power of the president?
I'm coming back for that one.
Come on back for that, yeah. And again, thank you all for coming. Thanks for the great questions. Have a wonderful evening. Awesome. Thanks again.
Yeah.